Hi, my name is Lisa Sumner with Nexum Pruitt's Creditors' Rights and Bankruptcy Practice Group. In the first of this three-part series, I'll explain how involuntary bankruptcy cases get started in the U.S. court system. Maybe you've heard that a person or a company can be forced into bankruptcy by someone else. Perhaps you're a business owner who is worried that your creditors will put you into bankruptcy, or you're a creditor who has exhausted the usual collection methods yet still remains unpaid. There aren't many legal requirements for filing an involuntary bankruptcy petition under the Federal Bankruptcy Code. The same basic requirements apply regardless of whether the alleged debtor is an individual or a company. An involuntary petition must be signed by one or more petitioning creditors. If a debtor has less than 12 creditors, then only one petitioning creditor is required to sign. If a debtor has 12 or more creditors, then at least 3 petitioning creditors are required. The claim a petitioning creditor holds against the alleged debtor needs to be relatively certain in liability and amount. In other words, if the alleged debtor has a bona fide defense to liability for the claim or disputes the claim amount, the creditor cannot rely on that claim to support an involuntary petition. The petitioning creditor's claim needs to be unsecured by collateral. This means if the creditor has a lien on the alleged debtor's assets and could be paid in full if those assets were sold to pay the debt, then the creditor is not an eligible petitioning creditor. Lastly, the Bankruptcy Code requires the petitioning creditor's eligible claims to equal or exceed a minimum dollar amount once added together. The current threshold is $16,750, but this amount is increased periodically to reflect inflation. A bankruptcy attorney can advise you of additional requirements that might apply to your case. On behalf of Nexum Pruitt's team of bankruptcy attorneys, we invite you to contact us if you'd like to discuss these issues.